good afternoon, almost good evening. Thank you all for staying with us through this long but very interesting day with lots of good conversations. And I know I've taken a lot of great notes, so I hope you all have as well. But we are not done yet. For those, particularly those that need CLE credit, this ethics session is incredibly important, but there are also some very interesting topics that will be discussed. I am a trademark lawyer, and so of course, I have great interest in Bill's topic, which you will see short, William Thomashower's topic, which you will see shortly, as well as Aisha's presentation that's more general on ethics as well. So without further ado, we will begin our ethics session. And please make sure you stay to the end for the CLE code for those that are online. And so I will now turn it over to Bill.
All right, thank you, Tasha. Aisha's also presenting. She was going to be here with me, but she's doing it remote, so I'll go first, just because I'm here live, and I don't mean to trump Aisha. I know she's online here. As Tasha said, she's very interested in this one, and that's because she is a longtime official at the USPTO in trademarks, and my specialty, one of them, is trademarks. And I am talking on a real pet project of mine that started even before last year, which is, and all of you who are filing trademarks in the USPTO know this problem. It's a very big problem. It's an ethical problem. And that is that there is a huge influx, and it's been over the last 3 years, of foreign applicants who are filing nonsense words and getting them registered, apparently because their foreign actor governments pay them off for getting a US registration. What is the purpose of that? Do we need the FBI to figure that purpose out? Who knows the purpose of that? The only thing I can think of, it's like a denial of service attack. If you have enough people overwhelming your website, the website won't function. Sure enough, pendency now, instead of being, when I started years ago in trademarks, I could get an office action in 3 months, 8.4 months now. That's on the dashboard, uspto.gov. Tasha's nodding her head. She knows that. And that's in here. So it's very unethical to do this. And the PTO should be credited for trying to stop it in a couple of different ways, but they have not succeeded, is part of my story here. So we call this ethical considerations for US licensed attorneys filing foreign-owned trademark applications for nonsense words. That's what's on screen here. And the point of that is that one of the things the PTO did to try to control this open foreign filing, before they adopted a rule, I think it was in August 2019, that said that you could not, if you were a foreign domiciled applicant, you needed to have a US licensed attorney. Because before this, uspto.gov was open to everybody to file anything, anytime. Particularly, you didn't have to be an attorney, you didn't have to be a trademark attorney. And I think it's a little too much DIY, do it yourself. And I've criticized that. There's a lot of stuff on the PTO website about how do you search your trademark and things like that. It really, it's not as simple as they would like to make it sound. I appreciate we're trying to help small business people do it themselves. It's dangerous. I see a lot of mistakes being made, and then clients come to us later, oh, what did I do wrong? Well, a lot of things. For example, just to take one, when you have a statement of use, you don't only have to show one specimen of your use on intent to use application. Oh, I've got it on sale. And so when they don't have legal counsel, they say, oh, good, now I can file statement of use. No, you listed 10 items there. All 10 have to be on sale, not one. Otherwise, you have to divide your application or abandon what you're not selling, okay? Or defer your statement of use till there are also 3 options. Why is that? Because a lawyer is professionally trained to find 3 problems with every solution, according to a famous old litigator who I heard of. And I've added to that, but a lawyer is also somebody professionally trained to find 3 solutions for every problem. Okay, so come to us. All right, let's see if we can get through some of this. So the answer was that this idea of, go back here, this flood of foreign-owned trademarks they tried to stop it by getting US licensed attorneys to have to sign on to every foreign application. Good idea. What they didn't think of at the PTO was that there would be some licensed attorneys who would think, oh, that's a great way to make a lot of money. I can do thousands of these at $40 a pop. And it'll still work because apparently what the foreign government's doing, and the record is that it's apparently mostly from China. I'm not picking out one country improperly, but this is what the data shows. They are paying a premium in dollars to anybody who gets a U.S. trademark registration, and the amount they pay exceeds the application fee. So it's a profitable enterprise. Well, you give that concept to engineering-oriented people any place, particularly in China, where they're very creative. Oh, I can do this. And they learn very fast the techniques to do it. So let's see if we can go through why this is a problem. So all these U.S. attorneys who are doing this without looking at what they're doing and without making sure that the specimens of use are correct, they're in violation of the PTO rules of professional conduct. Let's see, we'll move this. So this is just the rights. It says this is my opinion and not my firm, Pryor Cashman, and not the PTO and not IIPSJ, but it's all accurate, in my view. All right. So this is the problem. There's a drastic increase in the number of these nonsense words. And we're going to come in a minute to why do they apply with nonsense words? We're going to come to that. This is a quote I got from, and I credit them, the IP Watchdog in October of 22. They put together some data. It only runs up to 2017, but the problem is continuing. The emphasis added where I said, such as the Chinese government issuing subsidies for individuals who register trademarks in foreign countries, including the United States. That's something that I put in bold, because that is the problem. And the PTO claims these fraudulent trademark applications from China surged after several Chinese cities began offering these subsidies. So there's going to be more in the PowerPoint than we can sit here and read through, and I don't want to spend the time to read through all of it, so I'm just going to try to summarize some of these things. As I just said, top of this page is telling you that what happens here is that the government of China pays more than the cost to file the filing. So that makes it very profitable. But the object is they only do it if the filer gets the registration. So the filers have to be very clever. What is the fastest way to get something through the PTO without a problem? So you don't want intent to use, because then you get a notice of allowance and you have to file more things. That's too slow. So you don't file intent. You say, I'm using it now. But to be using it now, I need a specimen. And I also don't want to accidentally step on somebody who's already out there with a registration, and I don't want to search for it. That's crazy, because I'm trying to just get this through fast. So just reach in a bag that has all these letters A to Z and pull them out and create any crazy mark that you can't even pronounce. And most likely you won't accidentally get a 2D rejection. How's that? Although there's some examples where that hasn't worked for them. So as I say at the bottom of this page, these are the features that the applicants use. They use these nonsense letters for the very deliberate reason to avoid an accidental 2D, not an English word. So you're not going to accidentally step on somebody who's using a trademark that's either an arbitrary, like Apple for a computer, it's not a fruit, that's an arbitrary use, or even a fanciful mark like Exxon, EXXON doesn't mean anything, okay? Kodak doesn't mean anything. So you can get these fanciful marks, or you can use arbitrary marks, but they're all pronounceable in English. So what these foreign actors do is they create this jumble words, which we're going to come to, that you can't even pronounce. And those, when the examiner looks at it or searches it, well, they don't find any problem with that, at least from a 2D standpoint. So as I say here, that avoids the 2D problem, 2D meaning Lanham Act Section 2D, likelihood of confusion. Next thing is, well, they want to get it registered because they only get their reward if it's registered. So they do a use-based filing. This is where they cross the line. The goal is to get immediate registration. So they always want to claim that it's in use. That way, if it clears the 2D, clears examination, then it goes to publication. And if nobody opposes it, it gets registered. And then they get a certificate of registration. Now it's electronic. And they send that, I guess, to the Chinese government. They get paid. And maybe they do 100 of these a month. I don't know. It's getting very serious. But to do it, you have to have proof of use. And so on this slide, I call it bogus specimens of use. You have to show how you've used it. But now the internet allows you to sell on the internet, and the PTO will accept that for a bona fide use. How do you do that? Oh, we know how to do that. We put it up on Amazon or on eBay or on My Shopify. And when you start delving into these applications and look at what they've put up for use, you see almost on the face of it that it's phony. Aisha and I did this last week getting ready for the program. We found somebody, all of his statements of use, and I'm going to say him, I mean the applicant, although he used the U.S. attorney, all of his statements of use said residential, but they actually landed on commercial properties. There was a gas station, there was a 7-Eleven, and the 7-Eleven, they didn't even give the address. It just said 7-Eleven in a particular city. So the examiners should be busting these things, but apparently the examination guys, the examiners are supposed to, not be the investigator. They're supposed to look at it, and if they think it's okay, although now I think they've improved the examination guide to ask follow-up questions and maybe stop some of these. But examiners, they're overwhelmed. That's why the pendency has gone from 3 months to 8 months. So they take a screenshot, the applicant takes a screenshot of a bogus internet sale. One I saw just the other day preparing this lecture is, you're gonna come to it, somebody applied for JW Marriott for protective glasses. So they photoshopped JW Marriott onto the protective glasses, put it up on eBay for sale for $3. Oh, but the shipping price is $10 because it's coming from China. Okay, somebody gonna do that? I'm gonna pay $10 because I want the JW Marriott glasses for $3? Wait till the real JW Marriott gets this, okay? Actually, they probably don't need to because they have some class 9 applications, which is what this is in. So the examiner may actually bust that one for a 2D. But that's what happens when you get too cute, as opposed to using a jumble of words. Let's see what's next. So the foreign applicant, since that's the source, this is what you need to be watching for, right? These applications are typically made from foreign domiciles using a US licensed attorney. So point 5 on this slide that we're looking at now is that the requirement of a US licensed attorney has to do something to stem the tide of this fraud by examining. And they're ethically obligated to see that there's a good faith basis, which means that they should be looking at this and looking at the specimens and saying, is it okay? And this rule was put into effect August 3, 2019. Turns out it doesn't work because they go through and they just rubber stamp everything because they want to make the money. They're being paid to be the US attorney on the case. The next rule that this come in is the identity verification rule, which we see here on this slide, August 6, 2022. And that's also an effort to make only the filers be actual real people. That's good, except again, if you're being paid as a US attorney to do some of these, you're going to make sure that you have your identity verification in place so that that is easy for them to meet. They're real people, they're not bots. It's known that the USPTO is not being effective on this, and I don't mean to criticize USPTO, they've responded to this, but the Inspector General's report for 2021 appears in the PTO's annual report with this criticism as to what they need to do to improve and stop these foreign filers from overwhelming the system. So I put that in here so you have it. It's underlined that they said the current process is not effective in preventing fraudulent or inaccurate registrations. So the problem is well known, it's not being solved, but there's some efforts being made. So last year, this is really fun. Last year here at the IIPSJ presentation, I was lecturing on, can you get a trademark for marijuana or for hemp, et cetera? The rules have been altered. And I ran across one. Somebody applied for what you see here, the mark is KHMSYOG. Can't pronounce it. It's not a word. As soon as I saw that, I said, oh, wait a second. That's a phony foreign application. So I looked it up. They wanted it for CBD or a marijuana-based thing. That's how it came to my attention. And the page, when you go look at it, there it is. That's how it was filed at the time. And they say, as they like to say, can't read it, but the second line translation says, the word blah, 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 you can't say it, has no meaning in a foreign language because they want to teach the examiner that you don't have to translate this, you can let this go. And then the description of the goods was, something to do with CBD. Then you decide, well, then I decide, let me see who filed this. So I look it up, it's public record, and I see, oh, this was filed by attorney Weibo Zhang on this slide. So I made that so that it's an immediate reverse search, okay? I now see what appears to be a questionable filing from China by a US licensed attorney named Weibo Zhang, and I'm not characterizing what his nationality is, I don't need to, but when I search him last year, I found out, oh, he had thousands of filings He had 18,000 filings under his name. Look at that. Now that was as of last year, February 5, 2022. This doesn't jump out at you. How many minutes did it take me to put that together? Did we need the FBI to do that? No. So maybe because I gave it some coverage last year, the USPTO Office of Enrollment and Discipline picked it up and actually went after this attorney and got a final order that he suspended. I think suspended for too little time, but they suspended him just to see how he worked. The first 12 trademarks, when you do a search for his name of this 18,000, I said, okay, let me see what he's filing. Okay, it says 18,000 under his name. Next page, let's see the marks come up. There they are. Now you can't see them too well here, but if you look close up at the slide, they're all nonsense marks. 1 through what, and I don't care what class they're in, they're all nonsense marks. So it's clear what this individual was doing, okay? So this is when OED then commenced an action against Mr. Zhang. And there's a published final order, which I've attached as Exhibit A to my presentation this year, which shows what they did. They found 10 ethical violations, okay? And they suspended him. So this is taken from the final order that was issued recently. And they found he had filed 8,500 in 2020, 9,800 in 2021. So you'll notice that's starting to get up to the 18,000 number that I find. So it actually adds up. Paragraph 16, the Office of Enforcement and Discipline said, due to the volume of applications he filed, respondent did not always conduct a sufficiently thorough review of trademark applications prior to filing, including, for example, not performing the inquiry reasonable under the circumstances to determine whether the specimens showed the marks as used in commerce, or failing to review the specimens to determine that they were authentic. In other words, fraudulent specimens of use on Amazon, eBay, My Shopify, any place. The specific violations, if you read the order, it's an attachment A, they found A to J, that's 10. Letters A to J, violations of their rules. I pulled out letter I, which was that he engaged in conduct involving dishonesty by inter alia signing declarations representing that specimens showed marks as used in commerce when respondent had not performed any inquiry reasonable under the circumstances to determine whether specimens were used in commerce. And then authorizing non-practitioners to put his name on 49 trademark applications, because you can't do 18,000 of these by yourself. So he was just a mill, basically, to file these things. And don't take it from me, the PTO found this, okay? This is not a negative statement by me about a particular attorney. This is the findings in the final order. So there's another collection that the PTO has put up in their administrative sanctions section. That's on this slide. You can click it. And there are the listed, they found Zhang is there. He's number 1 on my list. But all of those, I don't know if those hopefully are clickable links. And if you can't click the link, I showed where I got it from. So these are a total of 7 attorneys who they found. I don't know if there's any significance to the names, but they're working mostly from China with Chinese applicants. And it's Zhang, Hao, Morton, Wan, Yang, Hom, and Liu. Again, we don't need to delve into what their national origin is, and we don't want to be discriminatory, but this is what the PTO found. And they were all suspended, according to the records, or the records will say exactly what happened to them. In general, they were suspended for different periods of time. Each one had hundreds or thousands of applications of this kind, these nonsense letters. And so the Office of Enrollment and Discipline has been working hard to do this. That's a good thing. They're trying to stop it, but it's not happening. They've also been blocked from using the system in the future. I think there's a ruling in most of these cases that their applications should not be relied on for some reason. I didn't get into the details of that, but you can read it. What is the consequence of allowing our USPTO examining division to be flooded with these things? Well, let's see. My analysis of the consequences are that the application volumes are hugely increased, right? So that overwhelms the trademark group, and it causes the first action pendency to go now from 3 months to 8 months. That means that a legitimate applicant, somebody who's not using mixed up letters and phony specimens of use, has to wait 8 months. Now, that's a real world consequence. If I have a client who's about to go to market and they want to file an intent to use application, they would like to know in 3 months if that application will at least have a 2D problem or not. They can't find that out now. They got to wait 8 months. So this is extending the time that you need to tell your clients, oh, you're thinking of using this trademark. Well, the PTO is so overwhelmed by these foreign filers, you need to start doing this sooner. You need to make these applications way in advance, which some businesses you can, some businesses you can't. In the auto industry, I think it takes them a long time to get the design of a new vehicle, so a new model. So they can certainly say, oh, well, this is going to be a new model that we're going to bring out in 3 years. We got to design the engine, the body. So, but at least we can come up with the brand now and start applying for that, see if that works. But in other industries, you know, you need to know whether your new product's going to have a good brand or not sooner. The next problem is that it's actually accidentally, they sometimes land on something which is a 2D problem. Even with a non-nonsense word, they could be landing on something that actually exists. I had that for one of my clients. Somebody applied for a word which just meant something in different language. So they thought it was a random word. And in fact, in the application, they said what we've seen here already. This word has no meaning in a foreign language and no translation in a foreign language. Actually, it did. It meant something in Greek. Okay. My client had it for a Greek restaurant. Here you go. And that's public information. I'm not telling you a secret. They're registered for 20 years with that. And one of these foreign actors came along to try to register it. And he gets it because he chose a class that had nothing to do with restaurants. Now I could oppose him or petition to cancel. That's just another problem. But this is what happens when you have too many of these random words. You're accidentally going to get a few that will block legitimate users or infringe a legitimate users or dilute your legitimate user who's been registered for a long time. The principal register is now cluttered with these nonsense words, which could inadvertently cause a 2D problem for a later filer, somebody who really is trying to get something and they have a real product. PTO has now made it possible to report these. So there's the links to how to report it. You can report it to OED. All these efforts, taking down 7 of the foreign filers, requiring verification of who you are, and requiring that you use a US licensed attorney, although some of them are driven by a financial reason to just do as much as they can without looking at it, has not stopped it. How do I know that? Because preparing for this lecture, I updated my own research. Again, it only took me 10 minutes. How did I do that? I skipped the slide. Yeah. So to do this, here's what I did. You take any, you guys, it's like a video game, okay? Test is a video game. I hate to say that. The trademark electronic search system can be used. You can have a lot of fun with this. I could teach my grown children to do it. They just have to be technically savvy. Take any class. I think what I did was I took class 9 because that's a very common electronic class. People like to file a lot of that stuff, particularly from overseas. And it seems to be very full of these foreign filers. So I said, give me every application test. Give me every application in class 9. I'm not asking you where it's from or anything about it. And the computer says, oh yeah, you have 1,850,000 registrations or applications of class 9. Then I say, okay, my Boolean operator, now let me add the name and address of the owner has to be from China. Oh, that's interesting. So now I get this list of, I can read the number here. 119,285, and the first page, as you know, gives you 100 of these. And if you look at these, they're all these mixed up crazy words. So by asking just for the restriction China and a class 9, but you can do it in any class. Go try it in class 25, clothing. Try it in class 35, for business service. Any class you like, class 3, chemicals. Anything you try, you're going to find it. Although more so, I think, in class 9. The first one, though, I fell down. I said, wow, look at this, J.W. Marriott. Could that be the real J.W. Marriott from China? So I looked it up. No, it's somebody from the story I told you. He's created glasses and apparently photoshopped the J.W. Marriott on. That's my opinion. That person has not been brought to the OED yet. So we're replaying sort of what we did last year. We're finding somebody who's filing a lot of things. How do we do that? So we then say, well, we'll zoom in. And this is what I found here on the first 12 of the 100. that were from China in class 9. Look at those words. One or two of them are sort of, pronounceable. Nikki at the end. And Marriott, that's a famous brand. Why would somebody go step on that? In medical. Some of these could be legit, but I doubt it. I haven't looked at them, so somebody can look at them. And I wrote, now you can be the OED's detective on tests and check the specimens to see if the specimens make sense. If not, and if you find somebody with 10,000 filings, you're going to know it's a problem. How did I figure this out? There's a footnote on this page. I was so impressed with the J.W. Marriott, I looked up who filed it, okay? And the filer is indicated there as an individual named Xiangyu Marang. So then I did the same reverse search on him. How many does he have in any class? Okay, answer. 6,002 applications under his name as the US licensed attorney. Does that tip you off? I don't have a docket. My whole firm, I shouldn't say that. The whole firm probably has a 6,000 docket. But one person can't have a 6,000 docket. Okay, that makes no sense. So maybe OED will go after that. And so that's my next slide is Aisha's slide. I'm gonna leave that for her. But that is the story of what we're dealing with right now. And as I say, it has real world consequences for you all out there filing legitimate applications for your legitimate clients with real specimens of use. And now you have to wait 8 months to get a first action. And you may actually find that you can't get it because somebody filed a nonsense word that's close. So I'll stop there and questions. I see Ulysses has a question. Check it.
Yeah, so what jurisdiction does the USPTO have over the attorneys that they're sanctioning?
Excellent question. So when you file with the PTO, you are subject, and it's not because you're a patent registered attorney like some of us are, but when you file as an attorney, you are stating that you are complying with the rules of Section 11. 37 USC Section 11 is the rules of professional responsibility for the patent office, which are very much like the rules for all states. They follow the ABA, so it's very common. And of course, you're not allowed to file something unless you have a good faith base based on factual review available at the time to believe it. So by having filed, they have subjected themselves. And they're all in the United States because you have to be a US filer. Right, okay. And if you look at those people who were brought in, the 7 who got final orders against them, they range from California, a lot of them in New York, but they're all over the United States. And that's the jurisdictional basis. But you can't actually go after the foreign filer because he or she is in China.
Right, it's
so
the
you
attorney.
Can't get them. But
I see.
That's
understood. Thank you.
Good question. Any other questions? I want to turn it over to Aisha. Okay. I guess I'll press the switch and see if Aisha comes up. There she is. Aisha, are you online?
I am indeed. And I'm actually going to share, I'm going to share my own screen here.
I think they have it up for you up here, but let me ask IT over there. Should she be sharing screen to do her slides? Okay, they say you should be able to share it. Right.
Okay.
It's working, we see
Okay,
it.
Excellent. All right. Okay, perfect. And to my little brother's question, he loves when I call him my little brother, Ulysses' question, we also see PTO cases in our office because a number of licensed PTO attorneys are also licensed in the District of Columbia. And so I don't actually believe that we do those as reciprocal cases, but we do see attorneys have discipline, usually not very serious discipline, but we do see them have discipline in DC as well. And also, I'd just like to say I had a lot of fun searching those bogus marks on tests with Bill on Monday. It's a really fascinating issue. It took me back to my PTO examiner days, minus the BD requirements. Okay, so I hope everyone can hear me. I thank you all for joining. I'm both excited and apologetic that I have the pleasure of discussing general ethics with you for the next 30 minutes. I hope the conference has been enjoyable. It's fantastic every year. I've been involved with the conference since my days at Howard Law School. I graduated back in 2005, so prior to that time. And I'm sorry I couldn't join you in person. COVID is not done with us just yet, as much as we would like it to be. And it seems like every day there's a close COVID case in my daughter's office. Is there a problem with the sound? No? Okay. Okay, so just a couple of words about myself. I'm a 2005 Howard Law grad, just as I mentioned. Once upon a time, I did practice a wide range of IP law, from corporate to litigation and patent to copyright law. But now I practice in the kinder, gentler space of disciplinary law. So I'm going to give just a quick disclaimer as well, like Bill, that the views that I'm going to express today are my own and not those of the board or the court. Okay, let's see. Excellent. Okay, let's get to this one. Okay. Now I'm well aware that I am the last speaker standing between you all and the start of your weekend, so I may not get through all these slides. I'm just going to cover the basics, and I won't go over. Ethics is really an interesting and kind of broad word. So I'm really going to focus on disciplinary law in the District of Columbia. I'm going to do a few things before I go. I'm going to make a pitch for those of you who are licensed in the District of Columbia and who have been licensed with us for at least 5 years to consider serving as volunteer judges in our system. We really do need you. I'll give you an overview of our disciplinary system, and then towards the end, I'll buzz through some areas of our law that tend to surprise lawyers, as well as a few fairly recent decisions by the board and the court. So this first slide that you're looking at just lists our board members. I'll discuss their role in the system shortly. They're all volunteers in the discipline system. All but 2 of them are attorneys, and the others are members of the public. This next slide just shows the members of our office. We serve kind of as in-house counsel to the board and its hearing committees. And again, here's my plug for the day. Hopefully some of you have seen my posts on LinkedIn to the Howard Law alumni group. We're actively seeking a diverse group of attorneys to serve as hearing committee members in the discipline system. And that's diversity in all of its respects: race, ethnicity, gender, practice area, in-house solo practitioners. The list really does go on. If you're interested, I would absolutely love to speak with you. Okay. Every state and jurisdiction follows their own sets of disciplinary rules. As Bill pointed out, I think most do follow the ABA model rules, but DC does have its own set of rules, which are not exactly like the model rules, but they're very similar. But there are some key distinctions. Of course, the rules governing the conduct of practicing attorneys are listed under the first bullet that you see there. And the more procedural rules that govern the disciplinary proceedings themselves are available under the latter 2 bullets. One of the helpful transitions that COVID did allow us to make, along with the courts, was to virtual hearings. We do still do them, and I'm pretty sure that those hearings are here to stay with us. If you'd ever like to view one of the hearing committee hearings or the oral arguments before the board, you can click on that link in my materials, and it will take you to a list of all those that we have upcoming, along with linking you to our YouTube page generally. Okay, so a brief who's who in the discipline system. The DC Court of Appeals established the DC Board on Professional Responsibility. While we do work directly for the court, the Board on Professional Responsibility is the disciplinary arm of the court, and it supports the court in the adjudication of disciplinary cases. There are 9 board members that you saw, I think, on my second slide, 2 of whom are members of the public and are not attorneys. That's actually somewhat unique. For example, Maryland uses judges to decide its disciplinary cases. So I think it's pretty cool that DC uses actual lawyers and actual members of the public who consume attorney services in DC to decide its cases. They're all volunteers and may serve 2 3-year terms consecutively. And then they can even serve longer. They just have to sit out for a year, and then they can come back if they want to. The court approves and appoints each of the board members, and the board generally meets twice a month for 11 months out of the year. But then we have our hearing committees. You'll see listed underneath the board. They're appointed by the board, and they have the delegated authority to conduct hearings on formal charges of misconduct and contested petitions for reinstatement, limited hearings on petitions for negotiated discipline, and hearings on any other matters that the court or the board may direct. It's a mouthful, but I'll briefly explain in a minute. Again, the board approves and appoints each one of them, and each hearing committee has 2 attorney members and 1 public member. And again, the same deal, they all can serve 2 3-year terms. On the right, you'll see my office, the Office of the Executive Attorney. And again, we support the hearing committee members and the board as they decide the cases. The Office of Disciplinary Counsel is there on your bottom left, and they are also appointed by the board. They serve as the chief prosecutor for attorney disciplinary matters involving active or inactive members of the bar. And on the bottom right, the respondent is the attorney who responds to the disciplinary complaint against him or her. And interesting fact about the disciplinary system, about the DC bar, I think we have the second largest bar in the country. I think it was the last I heard. I think only California has a larger bar than DC, which is very interesting given how tiny DC is, to me anyway, being a person from Philadelphia, like a small town. Okay. Contested cases. Our cases come in from all over. They come most often from clients, but they can come from judges. Opposing counsel can complain about an attorney's conduct. Really, any member of the bar can do that. And disciplinary counsel can even open a matter based on an incident that it reviews in the media. So just to give you some sense of the volume, in general, disciplinary counsel receives about 1,000 complaints a year, and it dockets only a few hundred of those and dismisses most of them. A complaint has to be docketed if it's one, not unfounded on its face, which means there's an actionable claim listed in the complaint, or two, it contains allegations which, if true, would constitute a violation of the rules of professional conduct that would merit discipline, and 3 is within the jurisdiction of the board. So they need to be a member of the bar, for example. We do get a fair number of complaints, especially you can imagine in this particular climate, against attorneys who folks assume that they are members of the DC bar, and they're not. They may be in New York or California or Virginia or the like, and those get dismissed. Another example would be complaints against judges, and those complaints are handled in an entirely separate process. We don't deal with those. A complaint will remain undocketed and it won't proceed any further if those factors that I just mentioned are not present. So as you can see from this chart, if a matter gets docketed, one of 2 things will generally happen. Behind door number 1, it can be handled with a diversion that's confidential, and it's used in cases of minor misconduct. In a case like that, the attorney will not end up with a record of formal discipline. They acknowledge that disciplinary counsel has filed a disciplinary violation, and they agree to accept the diversion. A written diversion agreement is prepared and signed by both parties. It might include something like a practice monitor. Once it's approved by a board member, disciplinary counsel will supervise the diversion until a satisfactory completion of that diversion has occurred, and ODC, we call them ODC, or disciplinary counsel can close their investigation. Behind door number 2, that's where the hearing committee members may serve as contact members and review petitions, dismissals, deferrals, and informal admonitions. Okay, so what are those? Petitions, as we call them, or specifications of charges, are the charging documents that disciplinary counsel files. The petition has to be sufficiently clear and specific to inform a respondent of the alleged misconduct and the disciplinary rule or rules alleged to have been violated. Dismissals may happen in a few ways. One might be that after their investigation, disciplinary counsel finds insufficient evidence to support the complaint. Another reason for a dismissal would be that there's a pending recommendation that the respondent be suspended or disbarred in another case. Informal admonitions are letters that are written by disciplinary counsel admonishing the respondent for some form of misconduct, which is typically minor. For example, if the attorney uses improper language in their engagement agreement, that might be the subject of an informal admonition. This discipline is publicly available, although I think way predating my time at the board, maybe, I don't know how long ago that was, it used to be confidential. Sometimes a respondent doesn't want to accept that discipline, and they actually fight an informal ad all the way up to the court. So when that happens, obviously disciplinary counsel has filed a petition and a specification of charges, and it goes through the normal process of a hearing and having the board review it and then going before the court. I've been shocked at the number of folks who want to litigate an informal ad all the way up, but they do it. And finally, deferrals. Those happen in cases, for example, where there are proceedings pending elsewhere, for example, in a criminal trial, and it might be more efficient to let that matter go before the disciplinary matter. because the burden of proof there is higher. So sometimes that can make more sense. Okay. Oopsie, did I? Okay, you can still see my screen. I just want to make sure I can see the time. Okay. All right. Hearing committee contact member review. Contact members are only attorney members. Public members don't serve in this role, and they review specifications of charges to make sure that the charge rule violations are supported by the allegations, as well as by the documents contained in their file. The specification must be supported by probable cause, even which is enough evidence to lead a reasonable person to believe that a violation of the rules has occurred. Okay. I think I screwed that up. Oops, I'm sorry. Okay, going to the contested discipline process. Okay, so once the specification is approved and is filed with our office, we will gear up for a contested case. This is just a quick view of our standard case track. You'll note there's an asterisk by the pre-hearing conference bullet. That's just because parties can often agree on hearing dates and dates for exchange of exhibits and the like in advance, so we don't hold pre-hearing conferences anymore when they can do that. Just a note about our hearings, they're bifurcated. So once the evidence is in and both sides have rested, the hearing committee goes into executive session to make a preliminary non-binding finding as to whether any rule violation has been established. Usually in most cases, that just takes a few minutes, but it can take longer. If the committee finds that they move into the mitigation and aggravation phase. Disciplinary counsel submits any evidence it believes the respondent believes should cause the respondent to receive a harsher sanction. So for example, if this is not respondent's first time through the discipline system, they'd introduce that evidence, and respondent would submit any evidence that they may have that they think would justify a more lenient sanction. So sometimes they might submit evidence that they were suffering from some kind of illness at the time of their misconduct that the hearing committee, the board, and the court should take into account. Disciplinary counsel has the burden of proof, so they go first. Again, there needs to be clear and convincing evidence that a rule violation has occurred, which just means that the committee has to have a firm belief that the violation occurred. The responding attorney goes next. Negotiated proceedings are a little bit different. The parties have agreed on the facts and the rule violations and what the discipline will be. The hearing committee will generally approve these so long as the facts in the petition for negotiated discipline support the admissions of misconduct and the agreed upon sanction is not unduly lenient. So similar to the contact member review process, the hearing committee or the chair reviews the file, meets with disciplinary counsel to discuss any issues that they see. If the committee recommends the approval, it goes to the court, it bypasses the board, and the court makes the final determination. I just want to mention two recent cases that were issued in the last few months that I did not include on my slides. Those cases are In re Burke and In re Teitelbaum. So before I started in this position, I really didn't appreciate the level of scrutiny that the court applies in its negotiated cases. In Burke, which I think was issued at the end of last year, maybe November, the court rejected a petition for negotiated discipline where the parties had agreed that the respondent had engaged in certain non-serious misconduct. I think there were some record-keeping violations and the like, which are not very serious. The court read the hearing committee's report and determined that it was not at all clear to it whether the client's funds had been kept completely safe at all times. This was not an issue that was at all addressed in the pleadings. So the court outright rejected the petition for negotiated discipline. In Teitelbaum, there was a similar issue. There, the respondent was holding funds on behalf of a group of legatees in a probate case. At some point in the process, there were insufficient funds to cover that which was owed to all of the remaining legatees who had not yet cashed their checks. Interestingly, the bank paid everyone, the account went into overdraft, and the bank then went ahead and closed the account. Nobody got hurt. But the court really still honed in on the issue of whether or not the funds had been kept safe the entire time. And as we're probably all aware, misappropriation occurs when the account balance dips below that which the attorney is holding on behalf of third parties. If the misappropriation was the result of intentional or reckless misconduct, then that's a disbarment offense in the district. It's not the case everywhere, but here it is. If it's less than that, for example, it's the result of some kind of accident or maybe sloppiness, it's a 6-month suspension here in DC. So again, the court sent the case back down to the board to get its views, but they didn't simply just accept the recommendation that the negotiated discipline be accepted. Okay, that's the negotiated discipline process. Reinstatement proceedings. These proceedings are how a respondent who was disbarred or suspended with a requirement that they prove fitness get back in and become members of the bar. If disciplinary counsel doesn't contest their reinstatement petition, it goes straight to the court. If the petition is contested, then we hold a hearing. In reinstatement cases, now the burden is on the attorney to prove by clear and convincing evidence that they have the moral qualifications, competency, and learning in the law to resume their practice. Okay, so I'm gonna keep an eye on my time, sorry. Okay, so I'm just gonna shift to talking about specific rules and sanctions that tend to surprise lawyers in DC, and some that surprised me when I started working in the office many moons ago. So I was shocked to learn that the disciplinary proceedings are quasi-criminal. I won't go to this one yet, are quasi-criminal. The way that this plays out in the disciplinary system is often, the way where I see it is related to due process issues. The system tries to ensure, for example, that the attorney has fair notice of the charges and evidence against them. You do not have a right to a speedy trial, as many a respondent has found out. We had another recent case, In re Stevens, also not in my slides, unfortunately, but if anybody wants any of these cases, I'm happy to send them. In re Stevens, the respondent was alleged to have engaged in misconduct, I think in multiple states, including Pennsylvania. Instead of responding to disciplinary counsel's inquiries, he elected to send a communication to disciplinary counsel's office saying that it would be an honor for him to be disbarred. The hearing committee held the hearing without his participation, and they issued a report that was over 200 pages long because his misconduct was really that extensive, and again, covering multiple jurisdictions. The board then issued a show cause order requiring the respondent to show cause why they should not recommend his disbarment to the court. The respondent replied not to the board, but to disciplinary counsel by sending a photo of Flavor Flav to disciplinary counsel, and underneath of it, he wrote, ODC is a joke. And the board then recommended, as a result of that he be disbarred. The court actually split 3 ways on this in deciding whether or not the appropriate procedural process should have been followed here. Which was very interesting because, as you may be aware, in the discipline system, delay is a huge issue. We have so many cases and there's a lot of process. And so there's a concern, there can be a concern about whether or not there are other ways to make our system more efficient. And the board was trying, to go the efficiency route. The court split 3 ways. But in the end, the majority, a slim majority, elected to disbar him. But it wasn't clean, a clear-cut decision that was the best route that all of the members of the court thought appropriate. Okay, the law on misappropriation is another area that continues to be interesting to me, as it's one of the most serious charges an attorney can be faced with here, shockingly. So this is the rule on safekeeping, just so you have it there, and that it doesn't say the word misappropriation, but this is the rule under which misappropriation cases are decided. There's been talk of amending the rule to clarify, and I'll talk about a case in just a second that is really spurring an amendment to this rule to really clarify for the public what they need to be doing. So what is misappropriation? Many lawyers believe that it's theft. Many hearing committee members who come, who start hearing committee service believe it's theft. It's not theft in the disciplinary system. It's actually any unauthorized use of entrusted funds, and it's not limited to client funds. I had a recent case where the attorney paid their clients, but they were holding funds belonging to medical professionals. He still was determined to have misappropriated those funds when they were moved from the trust account. The analysis in DC, and I presume the other jurisdictions as well, is a 2-step inquiry. Again, as I was mentioning, first the court looks at whether the funds went missing from the trust account without proper authorization. If the answer is yes, boom, that's misappropriation. The next step is figuring out why they went missing. So if a respondent has intentionally removed them for their own purposes or to do something like pay office expenses, that's really easy, that's disbarment. The next 2 categories down are reckless, as I just mentioned, again, which is a disbarment offense, and negligent misappropriation, which gets you 6 months off. Okay, reckless misappropriation These are what the court refers to, have listed here as the hallmarks of misappropriation. The attorney ignored problems with his trust account that started a year before. And because the attorney was the sole signatory on the account at the time, did not closely reconcile his records and bank statements. That's how the court adopted a finding that he engaged in reckless misappropriation, as opposed to just sort of sloppiness, which may have gotten him something closer to 6 months. That's just my opinion, not that of the board or the courts. Let's see here. And again, the respondent doesn't have to have engaged in all of these factors for a court to find that they engaged in reckless misappropriation. Okay. In re Ahagotu just taught us that it doesn't matter how long the funds go missing. The funds were only missing for a single day in that case. Mr. Ahagotu really didn't know what was going on in his account. He lost control. The funds were missing again for less than 24 hours. No one got hurt. He promptly put them back once he realized what was going on, and he got disbarred. In DC, that means that he was out for, he's out for 5 years, and then he has to prove his fitness to practice law before he can be reinstated. Mr. Gray was yet another respondent who lost track of what was going on in his trust account. As I understand it, he thought that he knew what was going on, but he was wrong. The court often looks at the notices that a respondent receives and then ignores as well in deciding where that line is. And I think that was true in this case. Okay, in re Pons, this case is really hot off the presses. And actually, this is the one that I mentioned might be causing a change to our misappropriation rule. In Pons, the court disbarred the respondent for reckless misappropriation. He attempted to obtain the client's consent to take a flat fee out as his own property before he earned it, but he failed to provide his client with sufficient information in order for that to have been considered informed consent, the level of informed consent that's required under our case in re Mance. The court focused on the issue of whether the failure to give informed consent was negligent or recklessly done. And the court relied on the hearing committee's findings that the fee agreement that he signed with his client, one, failed to explain that the respondent would have to refund any unearned portion of the flat fee. Two, did not advise the client that he would otherwise have had to place the flat fee in an escrow account but for this agreement. And three, did not explain what an escrow account was or what risks are involved when funds are not kept in an escrow account. So again, that's not anywhere that in our rules. You can't just read the rules and pick that up. You could read Mance and glean it. So that's something that it seems is being considered in attempting to amend the rule, but we'll see what happens. This is just an ignorance of the law case where this is hard, where the respondent didn't quite understand the parameters of in re Mance, and it sounds like he tried to do that and failed, and he still had a negligent misappropriation charge. So ignorance of the law is no defense. Okay. Here's our competence and secrets rule. That's another one that's interesting. I just like to flag that one because it's another one that surprised me. Based on the plain language of our rule 1.6, it even covers pillow talk. We had a recent case where a lawyer was found to have violated this rule because she shared a secret concerning a client with her boyfriend. I didn't include that one because it was just decided by the hearing committee and is now pending before the board. I did include in re Keck here because I believe she was in-house counsel for a corporation, and she shared confidential information with a news reporter, as well as the U.S. Attorney's Office and the SEC. And so she was given a 60-day suspension. So that is another significant rule violation. Lastly, another one that surprises me is the dishonesty rule. We see a fair number of cases involving charges that an attorney has engaged in dishonesty. And of course, our rule 8.4c prohibits conduct involving dishonesty, fraud, deceit, or misrepresentation. And the court has instructed us that 8.4c should not be accorded a hyper-technical or unduly restrictive construction. The court takes this very, very seriously, although one might argue less seriously than Maryland, because an attorney, it seems that an attorney might be more easily disbarred in Maryland for engaging in dishonesty in our sister state. Okay, and then this is a quote from In re Cleaver Bascom. I see this reference in a case almost once a week. Lawyers have a greater duty than ordinary citizens to be scrupulously honest at all times. We hear that in the office all the time. Scrupulously honest at all times, for honesty is basic to the practice of law. Every lawyer has a duty to foster respect for the law, and any act by a lawyer which shows disrespect for the law tarnishes the entire profession. The sanctions for engaging in dishonest conduct range from a public censure, depending on the context, all the way through to disbarment if it is considered flagrant, because it's extensive and protracted. Okay, and that's just In re Ton. That's another recent dishonesty case, and where he was deemed to have engaged in flagrant dishonesty because it was protracted and persistent. Okay, so that gets it from me. If anyone has any questions and I can hear those questions, I would be happy to take them. Otherwise, thanks to everyone, and you have a fantastic weekend.
Aisha.
Yes, of course.
Not to delay us from getting to our weekend at 5:15 exactly on the dot. You did a great job. But I have some experience with having been vice chair of the New York City Bar Association on professional discipline many years ago. And two things, one is a comment and one is a question. I believe there is a New York State Bar, where I am, ethics opinion that says you cannot have somebody listening in on a call as an attorney without telling the other party that that's happening. Obviously, if it's a criminal matter and you have a warrant issued by a federal magistrate, that's different. But in your ordinary conversations, that is deemed to be an element of dishonesty. So when I do that and I need my paralegal or a witness to hear the call, I will tell the person who's on the call. And conversely, when I hear that I'm on speaker, I will ask who else is in the room on speaker. I'm entitled to know that. That's a comment.
Very interesting. I'm admitted in New York too, so good to know.
All right, and now the question I have, and I think this is interesting. I recall some cases where we've been asked to file a disciplinary complaint with the appellate division, which is what covers it in New York, against an adversary client. In other words, let's put it this way: the client wants to file a complaint against the attorney for the adversary while they're in litigation. And very often we find that the disciplinary staff feels that's a litigation matter and they do not want to take that. They'll take it, but they won't take action on it until litigation is resolved. And maybe that they think that's going to be an issue for the judge, or they don't want to interfere with the proceeding. I was wondering what your view in the DC disciplinary view is. If somebody gives you a complaint about the opposing counsel in a pending case, will you proceed with that, or you will say, well, we're going to have to hold off on it? So there may not be an easy answer.
No, actually, this is a great question. So I will say I myself don't, I'm not in the Office of Disciplinary Counsel. I can tell you what I understand from our conversations with them, what their policies are. So as long as the complaint is valid and not designed as a sort of a tactic or to harass the opposing side, I don't see any reason why that would be improper. But I do understand that our disciplinary counsel does the same. They don't proceed with respect to a complaint against an attorney when there's an ongoing litigation, for that exact reason, as I understand it, so that it's not being used as a tactic or to harass, which again is actually specifically against our rules. But that's why they do it. But it shouldn't be. They may hold on to it, or they may tell you to come back and refile it once the case is over, remind us about it. It shouldn't have to go away. So I don't know if that's helpful, but they don't like to do it when the matter is pending. That's true.
That's helpful. Thank you. All right. Any other questions? All right. I think that does it.
Excellent. Thank you, everyone.